ଦେଖନ୍ତୁ ଦେଖିବା ନା ହଉଛି ପଲିଟି ବୁଝିଲା ନା। ପଲିଟିର ଏଇ ଯୋଉ ଭିଡ଼ିଓଟାକୁ ଦେଖିବା ରିଜନ୍ ର କରେଣ୍ଟ ଆଫେୟାର ରିଲେଟେଡ୍ ବହୁତ ଗୁଡ଼େ ଆମର ଏକ୍ଜାମରେ ଆସିବ ବୁଝିଲ ନା। ତେଣୁକିନା ମୁଁ ଆଜି ଏବେ ପଢ଼େଇବି ବୁଝିଲ ନା। ଦେଖନ୍ତୁ ନା ହଉଛି କ'ଣ ପଢ଼ିବା ନା ହଉଛି 50 ଇୟର ଅଫ୍ ନ୍ୟାସନାଲ୍ ଏମର୍ଜେନ୍ସି ପଢ଼ିବା ବୁଝିଲା ନା। ନେକ୍ସଟ ପଢ଼ିବା ହଉଛି ଡିଲିମିଟେସନ୍ କମିଶନ ବିଷୟରେ, ସେନ୍ସସ୍ 2027, UCC ବିଷୟରେ ପଢ଼ିବା, ରିଜର୍ଭେସନ୍ ଆଟ୍ ଗ୍ଲାନ୍ସ, ପ୍ରାଇଭେଟ୍ ଏଜୁକେସନାଲ୍ ଇନଷ୍ଟିଟ୍ୟୁସନ୍, ଲାଦାଖ and ସିକ୍ସ schedule, personality right, keyword, 13 practice question, issues and challenges pertaining to the federal structure, office of the governor and bill, the Supreme Court on assent to the bill, financial commission at glance, 16 finance commission, 16 Indus water interstate water dispute at glance, keyword, ତାପରେ ହେଉଛି ପ୍ରାକ୍ଟିସ୍ ଦେଖିବା ହେଉଛି ପାର୍ଲିଆମେଣ୍ଟ ଆଣ୍ଡ ଷ୍ଟେଟ୍ ଲେଜିସ୍ଲେଚର ଷ୍ଟ୍ରକ୍ଚର ଆଣ୍ଡ ପର୍ଟେନିଂ ଫଙ୍କସନିଂ, 21 disruption in parliament at glance, ଲୋକସଭା ସ୍ପିକର, ଆଣ୍ଟି ଡିଫେକ୍ସନ ଲ, ହେଉଛି ADL, representation of women legislator, ନାରୀ ଶକ୍ତି ବନ୍ଧନ ଅଧିନିୟମ ନୀତି ଯେଉଁ ଅଛି, keyword, ପ୍ରାକ୍ଟିସ୍ କ୍ୱେଶ୍ଚନ୍ ଦେଖିବା ହେଉଛି ଦେଖନ୍ତୁ ଜୁଡ଼ିସିଆରୀ ଆପଏଣ୍ଟମେଣ୍ଟ ବିଷୟରେ ପଢ଼ିବା, ଓମେନ୍ ଇନ୍ ଜୁଡ଼ିସିଆରୀ, ତାପରେ ହେଉଛି ଜୁଡ଼ିସିଆରୀ ପେଣ୍ଡେନ୍ସି ଆଟ୍ ଗ୍ଲାନ୍ସ, କ୍ରିମିନାଲ ଜଷ୍ଟିସ୍ ଇନ୍ ଇଣ୍ଡିଆ ଆଟ୍ ଗ୍ଲାନ୍ସ, କ୍ରିମିନାଲ ଲ ରିଫର୍ମ ଆଣ୍ଡ ଲିଗାଲ ଏଡ୍ ଇନ୍ ଇଣ୍ଡିଆ, ଅଲ୍ଟରନେଟିଭ ଡିସ୍ଟ୍ରିବ୍ୟୁସନ୍ ସଲ୍ୟୁସନ୍ ଆଟ୍ ଗ୍ଲାନ୍ସ, ରିଜର୍ଭ ରିଫର୍ମ, କଷ୍ଟୋଡିଆଲ ଡେସ୍ 35, ଟେକ୍ନୋଲୋଜିକାଲ ଇନ୍ ଜୁଡ଼ିସିଆରୀ 35 ବୁଝିଲା। ନେକ୍ସଟ ଆସିବ ହେଉଛି କି ଆକ୍ସେସ୍ ଟୁ ଜଷ୍ଟିସ୍, କିୱାର୍ଡ 77, ପ୍ରାକ୍ଟିସ୍ କ୍ୱେଶ୍ଚନ୍ 38, ଇଲେକ୍ସନ୍ ଇନ୍ ଇଣ୍ଡିଆ ବୁଝିଲା। 39 ଉପରେ ଇଲେକ୍ଟ୍ରାଲ ରିଫର୍ମ ଆଟ୍ ଗ୍ଲାନ୍ସ, lower aging of voting, criminalization of voting, policy, political finance, e-voting, 3 page keyword, practice question देखिवा, governance, administrative reform, citizen centric, blockchain based, प्रगति, internet shutdown, digital colonial, digital constitutional at glance, online content regulation, AI governance guidelines 54, AI governance through technology framework, democratic AI, balancing AI innovation, copyright, AI in public service governance, regulation of India pharmaceutical, 59, tribal grants, Panchayat extension to schedule area act 1900, trust based governance, land registration system in India, sport administration, national sport act 2025, food sectoral reform in India, 68, keyword, provide question of local government, PRA influence finance at glance, PRA influence at glance 70, urban governance, urban governance of USA and India, next देखो rural transformation through this AI in rural India, keyword 74, practice question, important act legislation 74, IT amendment rule 2025, 75, digital data protection 50 act, promotion and regulation of online games 2025, active FTRC act 2000, prevention of corruption act 1988, practical question 83, for constitutional practical and all executive body 84, Union Public Service Commission act, National Medical Commission, local in India, keyword, practice question, and experience. नेक्स्ट देखा देखो आलोचना करवा विभिन्न प्रकार ये सब रहा देखो कॉन्स्टिट्यूशनल इंडियन कॉन्स्टिट्यूशन प्रोविजन एंड बेसिक स्ट्रक्चर देखो 50 और नेशनल इमरजेंसी देखो मुझे कही मार्क 25 योर सील्स इंपोजिशन ऑफ नेशनल इमरजेंसी डिक्लेरेशन जून 25 1990 मार्च 21 March 21, 1976, why emergency was in social and large scale protest strike and demonstration. There is a movement led by Jayaprakash Narayan. Economic crisis first 1971, inflation 23% about 1973, 80% in 1970, 30% in 1970. For unemployment, economic stagnation exaggerated by global oil crisis, political factor, Allahabad court had Indira Gandhi election case validate କରାଗଲା ବୁଝିଲା judicial conflict tension with judiciary including appointment of justice and the chief justice federal dispute major constitutional amendment बुझिला 38 Amendment 1907 direct judicial review of emergency declaration by the making president certification to find under the Article 352, 356, 360. 39 Amendment Act 1975 changes in method of deciding election dispute of president, vice president, prime minister and speaker to be decided by such as by determined by the parliament. 42nd Constitutional Amendment Act 1976 Directive Principle over Fundamental Right under Article 31C curtailment of powers Supreme Court and High Court by the various measures like Article 30A, 32A instead of denying the power to consider constitutional validity of state law committed by the 42nd Constitutional Amendment Act deny HC power to check constitutional validity of central law Article 313A and Article 22A extended Lok Sabha term from 5 to 6 years बुझेला देखना ମୁଁ କହିବି national emergency article କେତେ ନା 356 ground for imposition war external aggression बुझेला armed conflict बुझेला purpose to protect sovereignty unity integrity security democratic system and constitution proclamation of national emergency president can declare emergency after receiving a written communication about the cabinet decision with approval by both approval Lok Sabha and Rajya Sabha within 1 month which will majority of the parliament membership of house of the by the majority of not less than two-thirds of the member of the house present and voting within a special majority. Duration indefinite period proclamation one proclamation per month period unless reversed by the president Lok Sabha and president resolution disapproving in and not in Rajya Sabha national post emergency reform Saha Commission 1977 to like sterilization government employment pursued retired censorship of courts and parliament 44 Constitutional Amendment Act 1990 under the Article 352 ground of imposing 44 Constitutional Amendment ground imposing armed rebellion instead of internal disturbance ଏଠୁ ଚେଞ୍ଜ କଲା internal disturbance ଆଉ national emergency ଲାଗି ପାରିବ ନାହିଁ କିନ୍ତୁ ତା ପରିବର୍ତ୍ତେ armed rebellion ରେ ଲାଗିବ to court misuse Union Cabinet written advice to the President compulsory mandated special majority parliament approved within 1 month. Fundamental right Article 21 during the emergency under the Article 359 right to property remove fundamental right constitutional right under Article 300 Article 275 remove to deploy arms for Union state Lok Sabha term back to 5 years from the 6 years and restore judicial power to review presidential and vice president election review emergency remain was power can suppress right vigilance democratic must always protect constitutional liberty ବୁଝିଲା ଦେଖନ୍ତୁ ଏବେ ଦେଖିବା ହେଉଛି delimitation commission delimitation is the process redrawing of boundary of parliament assembly constituency to ensure equal representation based on population therefore strengthening by representative democracy article 82 and 170 ବୁଝିଲା ନା କଣ କରାଗଲା ନା ହେଉଛି ଦେଖିବା ନା ହେଉଛି article 82 170 provide readjusting of parliamentary and state assembly constituency after every session provide readjustment of parliamentary and state assembly constitution after every session that was article 3 330 and 332 ବୁଝିଲା ନା now providing refixing of seat of scheduled caste and scheduled tribe in Lok Sabha and state legislative assembly बुझल ना article 330 and 332 बुझल ना नहीं now providing for a refixing reservation of seat for scheduled caste and scheduled tribe in Lok Sabha and state assembly बुझल ना delimited बुझल ना नहीं constituent in 1952 1952 1963 1973 and 2002 to carry out the delimitation exercise. Legal status order of the delimitation commission have been first of law and generally cannot challenge in the court. The significance of the delimitation for political equality ensures the principle of one person, one vote, one bill through the balanced representation. Preventing gerrymandering. Significance of delimitation constitutionally restrict arbitrary manipulation of constitution boundary and safeguard electoral integrity. Federal determine representative of state and parliament state legislature. Historical adjustment. Realign constituency according to demographic challenges for balance and representation. Effective governance. Create manageable constituency enabling representation to address local needs of effectiveness. Issue associated with delimitation. Federal imbalance population based state allocation may favor high growth state while reducing representative of state that successfully control of population. Representation imbalance. Delay in census affected to time readjustment to delaying the representation of elections representative reservation of constituency. Reservation of ST/SC seat may not allow reflect their actual demographic disturbance. Limited population participation, delimitation, decision largely commission driven with limited stakeholders. Judiciary pronouncement related to delimitation. Magraj Kothari versus Delimitation Commission 1960. Magraj Kothari versus Delimitation Commission held that judicial interference should remain limited, avoid disruption of election through review is not absolutely barred. Review is not absolutely barred. Color Magraj Kothari versus Delimitation. Kishore Chandra Changlan Rathod versus Union of India 2024 रे held the Constitutional Court may review delimitation commission order where there is manifested arbitrary देखिबा न होची TFR seat to election use the total fertility rate adjust formula balance representation and power population control greater transparency increase stakeholder and competition and public participation during delimitation effective preserve community cohesion especially SC/ST population ensuring accessibility voter representative interaction and electoral balance federal fiscal federalism finance commission should review democracy performance in addition to population size and income while allocating funds. Census 2027 देखो the Union government recently rolled out the first phase of the India Census 2027 launching the world's largest administrative and statistical exercise. Census in India. Decentralized census offer vital demographic, social, economic data held regularly since 1881 and 2021 census was delayed due to COVID-19 ବୁଝିଲା constitutional mandate article 246 seventh schedule union list of entry list ହଉଛି ନା ହଉଛି 69 ବୁଝିଲା legal provision conducted under the census act 1947 census rule 1990 ବୁଝିଲା ନା ନାଇଁ census rule ହଉଛି 1990 conducted by office of the registrar general ବୁଝିଲା ନା commissioner of India under the Ministry of Home Affairs बुझिला what is the new in 2027 census first digitally enabled data collection will rely on mobile application rather than paper census management and monitoring system CCMS portal for the newly time tracking house listening housing sensor HLO mobile app and web mapping tool called housing block creator बुझिला housing listing block creator बुझिला self enumeration बुझिला ना web based the public allocation enumeration 16 different language बुझिला 16 different language caste system enumeration during the first phase for the communities beyond the STSC in since 1931 two phase of timeline बुझिला housing and housing census rolling from April to September 2027 phase second population illumination in February 2020 significance of the census welfare and policy plan provide updated socio-economic data and accurate targeting subsidy identify the deprivation and better infrastructure planning tail insurance and political representative from the basic for the demolition and implementation of women reservation bill for the legislative assembly बुझिला understanding the new democratic बुझिला decline rate relief particularly align population बुझिला ना restructuring of the care and economic and health system तापर देखा होची urbanization and migration tracking GPS tagging and digital mapping बुझिला ना transport housing and climate resilient infrastructure rapid growth बुझिला ना देखा होची digital exclusion and privacy बुझिला challenges ये सब रही dependency on mobile access and digital it may exclude vulnerable group while digital sensor system rise cyber security and data privacy concern methodological complexity of caste India's diverse and localized caste identity administrative difficulty political sensitivity north-south tension population delimitation conduct reduce their parliamentary representation and despite their successful population control बुझिला नेक्स्ट आसीबो होची देखंतु ना होची सेंसर 2021 critical research a developmental and democratic framework if conducted its friendly representation welfare targeting and provide clearly picture of India's socio-economic reality towards Viksit Bharat 2047 बुझिला ना तापर आसीबो होची यूनिफॉर्म सिविल कोड बुझिला यूनिफॉर्म सिविल कोड रो कोन सब रहिछि से सब बाबत रे हमें जानिबा why in Gujarat became the second state of the state after the Uttarakhand to pass a uniform civil code bill बुझिला आर्टिकल 44 रे अछि बुझिला देखंतु यूनिफॉर्म सिविल कोड unified system of personal law applicable to all citizens regardless religion covering matters like marriage, divorce, maintenance, inheritance, adoption, and property success. Current status. Most Indians are governed by their respective religious personal law. Goa followed from the UCC under the Portuguese Civil Code 1816, 21st Labor Law Commission, 21st Law Commission 2000 often though ECC is neither necessary desirable currently recommended gender just reform बुझेला ना नहीं family religious family बुझेना देखो ECC 1963 रे हतला साहाबानो केस बुझेना साहाबानो केस रे अछि कोन हतला emphasis on justice and gender justice बुझेला uniformity in personal law सारला मुदगल केस होची एससी कॉल फॉर यूसीसी एंश्योर जेंडर इक्वालिटी एक्शन सारला मुदगल केस माने जेंडर इक्वालिटी ऊपर कथा कहगला 2003 रे जॉन भेलापुरम मैटम केस यूसीसी आज वाइटल नेशनल इंटीग्रेशन बुझेना नेशनल जॉन भेला मैटम केस रे कहगला 2000 यूसीसी होची नेशनल इंटीग्रेशन बाय अवॉइडिंग आइडियोलॉजिकल कॉन्ट्राडिक्शन बुझेना साइरो बानो केस बुझेला साइरो बानो केस होची 2027 instant triple talaq declared unconstitutional advertising women's digital right बुझेना जोसेफ पॉल cohesion case बुझेना आज six civil code in UCC check reforming religious freedom with uniform law बुझेला argument in favor of UCC देखा UCC रो फेवरमेंट रे कौन सब जाउछ upholding secularism provide common civil law propriety legal uniformity access practice promoting gender equality address the discriminatory practice like polygamy in Muslim law inheritance restriction faced by parsimony ensuring equal status align personal law with fundamental right under the Article 14 of right to equality national integration implemented one nation one law approach ensuring state neutrality internal obligation. India ratified international covenant on civil procedure and political rights 1906 CEDAO set up 1979 ensure gender equality under the national law बुझेला ई सब रहबो बुझेला तापर फेवरेट होची अपहोल्डिंग सेकुलरिज्म रहबो कॉमन सिविल लॉ रहबो promoting gender equality रहबो बुझेला discriminatory practice polygamy in Muslim or inheritance strict enforced by parsimony ensuring equal status to Article 14 ऊपर national integration one nation one law बुझेला ensuring state neutrality बुझेला तापर होची international obligation बुझेला ना international civilians on civil political right बुझेला pseudo बुझेला to ensure pseudo convention on देखो तो argument against the UCC threaten religious autonomy UCC may undermine religious freedom under Article 25 and 26 impact on marginalized section Naga minority community fears that UCC would pose threat to their culture and dignity against cooperative federalism UCC could encourage on state legislative power undermining cooperative federalism social unrest implementation without due consequence from the diverse community may lead to social unrest and resistance. Implementation issue UCC informs that may be difficult in remote or culturally conservative area could increase legal dispute. बुझेला ना तापर जे next होची way forward in implementing UCC in India. बुझेला ना public awareness government should hold national-wide consultative with all faith community to enable informed debate बुझेला sectoral reform they will bring adoption and guardianship under the secular federal like juvenile justice care and protection of children act 2015 बुझेला adopt harmonization model blend religious and secular law through the incremental reform example of Indonesia maintain pluralistic legal system allowing religious law applicable to Muslim enforcing secular civil code and for interfaith issue बुझेला ना अब जे देखंतु कंक्लूजन टा देखबा बुझेला ए यूनिफॉर्म सिविल कोड लॉ must balance equality secularism integration with socio-cultural diversity through the gradual and inclusive implementation बुझ देखंतु एबे आलोचना करबा ना होची यूनिफॉर्म सिविल कोड बुझेला रिजर्वेंस एक्ट क्लास बुझेला रिजर्वेंस कथा देखबो जे ना होची आर्टिकल रिजर्वेशन कथा देखबो कॉन्स्टिट्यूशनल प्रोविजन रिलेटेड टू रिजर्वेशन बुझेला रिजर्वेशन रे कोन सब कॉन्स्टिट्यूशनल आर्टिकल 15 फॉर बुझेला आर्टिकल 15 फॉर होची रिजर्वेशन एजुकेशनल इंस्टीट्यूशंस SCBC SC and ST बुझेला SCBC socially and educationally backward colors SC scheduled caste scheduled tribe ମାନଙ୍କର reservation କଥା କୁହାଗଲା article 15(6) and 16(6) 10% reservation for EWS for the administration in educational institution and public employment article 103 amendment act 2019 ବୁଝିଲା EWS 15(6) और 16(6) पे ये सब अच्छी 10% reservation for EWS and for the admission in educational institution and public employment 103 amendment act 2019 बुझिला article 16 for and 16 for the reservation post and service बुझिला article 46 promotion of educational and economic interest of SC, ST and weaker section of society बुझिला reservation of 243D reservation of seat of ST, SC in panchayat बुझिला article 3 बुझिला reservation article 330 reservation of seat in for SC and ST in house of the people बुझिला माने तापर होची देखिबा ना होची article 322 रो भी मजा होची reservation of SC, ST in assembly बुझिला माने तापर होची important judgment उडा को कोन अछि बुझिला इंदिरा साहा आणि वर्सेस यूनियन ऑफ इंडिया बुझिला 1992 रे आस्ला माने होची ना होची रिजर्वेशन अंडर 16 बुझिला हम जो 16 टा एटा पड़ला बुझिला ना होची SC ST मान करो होची माने SC BC SC ST बुझिला आ EWS मान करो ना कोन reservation टा होची not exceed than 15% बुझिला there should be no provision in promotion बुझिला ना exclusion of criminal layer बुझिला exclusion of criminal of from OBC बुझिला OBC मान को exclusion करा दे criminal M Nagaraja versus Union of India 2006 laid down 3 conditions to be followed implementing reservation and promoting state must be show quantifiable data on backwardness SC ST बुझिला fact about their inadequate representation in public employment reservation are in the interest of the administrative efficiency तापर असला जर्नल सिंह वर्सेस लक्ष्मी नारायण गुप्ता 2018 reservation in employment does not require state to allocate quantifiable data on backwardness of SC ST Janhit Abhijan of Union of India 2022 SC of 103 Constitutional Amendment Act and provided EWS reservation based on the economic criteria. State of Punjab versus other Devendra Singh versus other state 2020 for Supreme Court allowed soft categorization of scheduled caste for the purpose of the reservation within a citizen. Reservation in private educational institution बुझिला मतलब कि reservation in private educational institution रे कोन why in the department related standing committee education on children youth for in 370th report assessed the constitutional possibility for reservation in private higher educational institution बुझिला status of the representation in private building. Nationally, law representation only 10% in OBC, 0.5% in SC, 0.8% in ST. Out of 5,100 students, BIT high fee a barrier on unaffordable marginalized section society need for reservation in higher educational and dominance of private sector 65% of India college private unaided and 517 private universities exist. AIC 2021 to 22 data 65 of India college are 65.3% होची private institution बुझना public sector incapacity unable to accommodate student given growing UPSC 50 gross enrollment ratio in higher education तापर judicial pronouncement related reservation private तापर होची Pramati educational cultural trust Union of India 2024 Supreme Court explicitly upheld constitutional validity entirely of the 18 Article 15(5) Article 15(5) state must be state SCBC administrative educational institution provide minority institution recommendation for the private parliamentary mandatory through the legislature to fully implement Article 15(5) mandating 21 reservation for the OBC SC and 7.5 ST in private government financial responsibility. Any reservation in private HEI should be fully government funded online 25 RTI Act quota model in the private school informs criminal for the OBC regulatory eligible criteria benefit each must be determined. Outreach company collaboration with the NGO spread awareness in marginalized remote and communities opportunities. देखो लद्दाख एंड 6 शेड्यूल बुझे एटा तो जानी थे बहुत न्यूज रे थिला तथापि मैं आपको खाली टिके ओवरऑल देखि दउ काहे कि न्यूज रे थिला ना लद्दाख अंडर द 6 शेड्यूल टू ग्रेटर कॉन्स्टिट्यूशनल ऑटोनॉमी पे आतला बुझे रिजर्वेशन फॉर वुमेन इन लद्दाख ऑटोनॉमस हिल काउंसिलिंग तापे 80% गवर्नमेंट जॉब सिक्योरिटी फॉर लोकल बुझे ना तापे होची एडिशन टू 10% रिजर्वेशन ऑफ एड with our language policy in English, Hindi, Urdu, Marathi, and Purgi. Other constitutional benefit Ladakh will be if included in 6th category. Addresses local issues, safeguard and land, forest rights, safeguard tradition of the reserve management, issuing in awarded 6th schedule status in Ladakh. Financial vulnerability, inter-community dynamics with national security. Compliance increase autonomy might compliance coordination with central government limited of recent rules no constitutional protection article 240 with empower president to make regulation for active without legislature can be amendment or withdrawn by central entity no ban on land operated by outside due to growing tourism, construction and climate-related things, not legal legislation, counseling with law-making power. This is the contrast to power given ADC, autonomous regional council, ARC under 6th schedule. Limited cultural support, no clear plan to utilize local language in school governments and conclusion. Constructive dialogue and Ladakhi representatives, political leader and center is essential to balance Ladakh unique identity and aspiration with broader national framework, open communication and consensus building. Personal right. Personal right approach is highlight the recently productive personal rights Sadhguru Jogi Vasudeva from AI issued by Rogi वेबसाइट बुझेला देखिबा एटा की आलोचना करबा बुझेला देखो मु एबे कहिबी ना होचे अबाउट द पर्सनल राइट बुझेला तब individual right to be the control unauthorized use of personal authority name like name image and voice likeness are both commercial and non-commercial aspects बुझेला non explicitly mentioned in Indian law component of personal right is a right to publicly protect against unauthorized commercial use of like image or like partially governed by the statute like Trademark Act 1969 Copyright Act 1957 right to privacy for the कथा आसीबना public representative on personal right without consent broadly governed under Article 21 and case Putaswamy case judgment posthumous personality right in India no specific statutory recognition after this Enable Act 1950 prohibit commercial use of image Mahatma Gandhi and Prime Minister Deepak Jai Kumar versus A. A.L. Vijay 2019 personal right reputation on privacy with that challenges in enforcing personality right in India. No clear legislation no dedicated status for the personal right scattered protected under the IP law or constitutional law inadequate protection under the IP regime. ତାପରେ ହେଉଛି example of copyright law does not cover trait like voice or likeness ବୁଝିହେଲା ନା ଏମିତି ଦେଖିବା ହେଉଛି ICC international LTD ବୁଝିହେଲା PC average entrepreneurs ହେଲା ICC environment ବୁଝିହେଲା international LTD ବୁଝିହେଲା average enterprise ବୁଝିହେଲା Delhi HC protected personal right under the Article 19 and 21 Arun Jaitley versus network solution private limited ORS Delhi High Court affirmed the personality right on internet Rajinikanth versus Bosha production Madras High Court rule on unauthorized use of celebrity likeness violate personal right way forward new law needed definite threat mandate constant regulation AI set penalty stronger regulation AI generated data protection regulation GDPR general data protection rule general data protection rule general protection general data protection rule ତାପରେ ହେଉଛି ଦେଖିବାର ଅଛି ତାପରେ ହେଉଛି Department of the Telecommunications to monitor AI misuse ethical AI needed AI develop guidelines to prevent misuse of personal data ଦେଖିବା ଦେଖନ୍ତୁ include India needs a dedicated legal system to framework personality right AI diversity keyword caste elimination social unrest national security control of power sanctions management and monetary system portal sensor CMMS sensor management and monetary system gerrymandering and while present imbalance social unrest and law harmonization model personal law reservation in private education institution national security language protection religious criminal judicial curtailment of power fair representation fund allocation reservation constitutional professional based delimitation practice question Article 44 envisages as for civil corporation Article examining the guarantee for and against its implementation contemporary introduction define UCC argument in favor UCC argument against way forward एगुला सब लिखो issue challenges for pertaining to the federal structure विषय एगुला लिखो ये माने जैसा आप इम्पोर्टेंट पढ़ी थी पर्सनल राइट Governor is the constitutional head of a state in India, appointed by the president and the union in state. Constitutional provision related to governor established on Article 25. Governor the office each state some oversees multiple state. Example of union territory. Article 163 government act as aid and advice to council of ministers expect discriminatory power तापर देखिए Article 200 government assent to the state bill can withdraw return for recommendation expect money bill and reservation for president government assent to the state the bill can withdraw return for reconsideration expect money bill or reserve bill for president बुझेला ना 201 governor reserve the bill for president consideration can give assent withhold and return for the constitutional no time specific delegation article 213 power to promulgate ordinance during the assembly बुझेला article 356 recommend president rule in constitutional breakdown in the state बुझेला ना तापर देखबा roles and power executive power कौन अछि ना appointment the chief minister council of minister advocate the general state election commission oversees the state administrative legislative power summon and determination of state um, address census give assent to the bill reservation the bill for president consideration judicial review and pardon review of communication article 161 appointed justice and subordinate courts in consolidated with high court discrimination power act without ministerial advice in specific act in appointment chief minister for election remaining president role and reservation financial ensuring state budget and representation approve the bill financial bill was ensure the budget representation approve the money judicial pronouncement related to office of the government और जो शमशेर सिंह वर्सेस स्टेट ऑफ पंजाब 1974 बुझेला ना 1974 रे रहला होची clarified the government act on art air and advice council of ministers expert is in limited discrimination area SR Mumbai versus state of India the national rectified the misuse of article 356 president rule subject to the judicial review governor's report must be appointment president rule subject to the judicial review governor to the most of executive about the representation of Tamil governor of Tamil Nadu 2025 Indian Supreme Court emphasized governor neutrality in giving assent state bill in time bound manner next देखिबा तापर होची देखिबा कि सुप्रीम कोर्ट assent on the bill बुझेला ता विषय देखिबा लिखला 5 judge bench of Supreme Court 16th presidential reference under the 143 called that cannot impose any time of decision of president and governor or granting assent to article 200 to 200 constitution तब की judgment of 16th reference presidential deemed assent unconstitutional court cannot be assured assent to the bill merely because court order timely lapse and infringe the constitutional power president and governor violate the separation of power and federal constitution scheme governor president cannot sit on bill indefinite as a violate federalism legislature wills constitutional morality limited judiciary court cannot interference if governor president's act malified intent and review of the confidence to procedure and non-merit Supreme Court advice not required president need not seek to Supreme Court advice whenever governor reserve a bill for his or assent to subject satisfaction of president in sufficient for the other keyword state of Tamil Nadu and governor of Tamil Nadu judgment 2025 aspect and details in accusation in constitutional governor and parliament cannot explain absolute veto bills under the article 200 to 201 in action can be challenged by a writ and mandamus. Governor cannot re-enacted bill for president assent. Governor may reserve bill for president assent only once. After re-enactment, it can be reserved again unless materially adult. No absolute discrimination under 200. Governor is bound by CMO, Ministry of Council of Ministers advice expect constitutional special state bill that would derogate High Court power. Article 254 to relating a subject enumerated in concurrent list. Article 288 taxes on water and electricity. Article 360 financial emergency. 304 inter-trade commercial and Article 300A and Article 31A and 31C. बुझल discrimination power under article subject to judicial review. Withholding the assent reservation bill for the discrimination. The president withholding assent can be challenged Supreme Court. President constitution. President consulate Supreme Court bill on reservation unconstitutional. Article 143. Supreme Court intervention reaffirm constitutional accountability and ensures the legislation function in state. The judgment is a step towards the restoring balance between the constitutional and promoting cooperative federalism. ବୁଝିଲାନି ଦେଖନ୍ତୁ ଏବେ ଆଲୋଚନା କରିବା ହେଉଛି ଫାଇନାନ୍ସ କମିଶନ। ବୁଝିଲାନି ଫାଇନାନ୍ସ କମିଶନ ବିଷୟରେ ଆମେ ଆଲୋଚନା କରିବା। ଦେଖନ୍ତୁ ଫାଇନାନ୍ସ କମିଶନ ବିଷୟରେ ଯଦି ଆଲୋଚନା କରିବି ତାହେଲେ କେମିତି ସବୁ ରହିବ। ଫଙ୍କସନ ଅଫ ଦ ଫାଇନାନ୍ସ କମିଶନ ବୁଝିଲା କନଷ୍ଟିଟ୍ୟୁସନ ବାଇ ପ୍ରେସିଡେଣ୍ଟ ଅଫ constituted by the President of India every 5 years. Article 280 consists of chairman plus 4 members. Four members consists of chairman and 4 members. बुझेना तब से vertical devolution बुझेना vertical devolution ऊपर जानिबा ना है vertical devolution recommendation of sharing net union tax proceed divisible poll between the union and state. Article 217(1). Other channel vertical devolution grant in aid discrimination grant 208 to tax covered income tax GST and other central taxes considered by the financial commission. Horizontal interstate distribution decide criteria distribution of research among state grant in aids grant in aid recommendation financial assistance of state from the consolidated fund of India. Article 2751 suggest a measure to argument state consolidated fund to supplement research of municipality and other local bodies. Limitation of financial commission incomplete fiscal data non-binding recommendation incomplete fiscal data non-binding recommendation central state research that is balancing of state autonomy against increasing demand for centralized expenditure for the local body and indirect role by state finance commission GST council tax division alter finance commission division 16th finance commission filed in the news देखिबा 16th finance commission report a parliamentary February 1 2010 has fact debate cover whether fiscal transparency sufficiently balanced fiscal equality among the state and while addressing central growing expenditure need. 16th finance commission April 1 2006 to March 31 to 2031 बुझेना ये सब होते 16 फाइनेंशियल कमीशन चली वर्तमान बुझेना ना ताले देखिबा होते चेयरपर्सन डॉक्टर अरविंद पानगरिया टी सविरंकन अन्नी जॉर्ज मैथ्यू मनोज पांडे एंड सौम्यकांति घोष बुझेना टर्म ऑफ रेफरेंस टैक्स डिविनेशन grant in aid local bodies disaster management review disaster management act 2005 finance key recommendation of 16th finance commission within a vertical devolution of 41 same as the 15th finance commission then excluded cesses and success redressing state revenue horizontal devolution reserving grant in aid 9.47 lakh crore. Focus on local body disaster management, discontinue reform decision and other specific local body grant allocation 4.4 lakh crore, rural 3.6 lakh crore, urban share increase 45%, urbanization disaster management cooperation 2.04 lakh crore, STRMF for the state disaster response force Switzerland, STMF Switzerland sharing 19.90.10 in other which is 75.25 new national disaster gateway lightning recommended challenging related to devolution and shrinking devolution pool rising sharing census subject and fundable for funds available to state equity versus performance high income disaster weighted heavy favor less condition transfer of tide grant may contain special flexibility as a vertical imbalances state major expenditure and responsibility health education and welfare but possess limited tax power example reconstruction national rural employment guarantee program require state to review 40% program removal and revenue deficit grant rise issues equity and targeting specific state need described as a trinary of the base of the year. Recall that fiscal deficit a key action. Center 3.5 GDP end of the budget for a state of 3%. Next, Tekvana require pass discom privatization special purpose vehicle for development union incentive for capital investment subsidiary rationalization focus on for exclusion after which is sunrise close more budgeting funding PSA form clause PSA review loss making PSA closure and privatization disinvestment way forward which rationalization social to cooperative federalism within wider state constellation of refined criteria with a predictable untitled reference to enhance state level diplomacy autonomy conclusion 16 finance commission is pivotal balancing cooperative federalism prudence and equality shaping center state regulation sharing policy spending quality and localizing body and state in fiscal responsibility ତାପରେ ହଉଛି ନେକ୍ସଟ ହଉଛି ଜାଣିବା ଦେଖନ୍ତୁ ନା ହଉଛି ଇନକମ୍ ଡିଷ୍ଟାନ୍ସ 45.42.5 ପପୁଲେସନ୍ 2011 ହଉଛି 15% ଥିଲାବେଳେ ତାପରେ ନେକ୍ସଟ ହଉଛି 17.5 ଡେମୋଗ୍ରାଫିକ୍ ପରଫର୍ମାନ୍ସ ହଉଛି 12.5 to 10% ଏରିଆ ହଉଛି 15% 10% କମିଛି ବୁଝିଲା ଦେଖିବା ହଉଛି ନା ହଉଛି ଫରେଷ୍ଟ ହଉଛି 10% ଦେଖନ୍ତୁ ମୋ ପେଟ ପେନ୍ ହଉଛି ହେଲେ ବି ତଥାପି ମୁଁ ଟାର୍ଗେଟ ରଖିଛି ଏଇଟା ସରିବା ପାଇଁ ବୁଝିଲା 98 ପେଜ ରହିଛି ବର୍ତ୍ତମାନ ମୁଁ 19 ପେଜ ପର୍ଯ୍ୟନ୍ତ ସାରିଛି ତାପରେ 100 ରୁ 100 ହେଲା ଜିଡିପି କଣ୍ଟ୍ରିବ୍ୟୁସନ୍ ମିଲ୍ ଥିଲା ହଉଛି ଏବେ 16 ଫାଇନାନ୍ସ କମିଶନ ରହୁଛି 10% ରହିଛି ବୁଝିଲା ନା ଦେଖନ୍ତୁ ନେକ୍ସଟ ହଉଛି ଦେଖିବା ଏସବୁ କଲି ବୁଝିଲା ଏବେ ପଢିବା ହଉଛି ଇଣ୍ଟରଷ୍ଟେଟ ୱାଟର ଡିସ୍ପ୍ୟୁଟ ବୁଝିଲା ନା ISW interstate water dispute ବୁଝିଲା Ravi Gas Water Terminal formed in 1987 has got an extension another year to resolve the water issue between Punjab, Haryana and Rajasthan. Reason for the ISDWD asymmetric access to river water regulation upper riparian state enjoy advantage to access river water post independent boundary drown without river basin growth in population farming urbanization and economy Dams and water project trigger dispute example होची नर्मदा कावेरी river basin dispute बुझला fragmented water governance union government weak and structure of ISWD resolution बुझला state government divergent perspective and reductionist water management strategy unscientific approach no integrated river basin management बुझला non-uniform collection of river and flows of volume data बुझला legal constitutional framework to resolve dispute order measure to take and resolve ICWD legal and constitutional framework to resolve dispute other measure to take and resolve ICWD ISWD legal and constitutional framework to resolve dispute बुझला ना कौन सब legal constitutional framework होची देखिबा होची article 262(1) parliament can provide law dispute adjudication article 262(2) बुझला ना 62.2 बुझला parliament में bars SC and other court jurisdiction of such dispute बुझला ना तापर रहइबो ना law under article 206 river board act 1956 बुझला interstate river water dispute act interstate river water dispute act 1956 बुझला union may establish tribunal of state list बुझला 7th schedule union list entry 56 regularization of interstate river बुझला state list entry list 17 water use irrigation subject to provision of entry 56 बुझला तापर होची देखिबा ना होची interstate river water dispute amendment bill 2019 dispute resolution committee to resolve dispute amicably establishment of single ISRT tribunal with multiple benches data bank at central for each river basin draft river basin management RWM bill 2018 objectivity equitable and sustainable use of water interstate river basin management etc creating river basin authority and master plan the challenges in resolving ISWD interstate water dispute constituting tribunal example Kaveri tribunal for 1990 after decade tribunal award delivery example Narmada 9-year Krishna 4-year Godavari 10-year uncertainty due to decline in publishing tribunal orders in Gazette example of Krishna 1956 tribunal to declaration published gazetted in equal SC declaration of politicalization water dispute politically disregarding environment social and cultural aspects lack of stakeholder participation local community state indigenous population often excluded Supreme Court intervention so it cannot be undertaken Supreme Court interfered tribunal award causing delay in example Kaveri 2007 final SC wanted letter came modification cooperative federalism union government act as mediator to reach mutually expectation solution create forum for dialogue and discussion on interstate water under the Niti Aayog बुझला ना नहीं तापर देखबा ना होची policy intervention bringing interstate water dispute under the state interstate council 163 article बुझला amendment ना होची interstate river water dispute act 1956 बुझला आगु होची river dispute board बुझला river board act 1956 अच्छी बुझला ना तापर होची legislation तापर होची expedited interstate water dispute amendment bill RBM 2018 for punctuality बुझला तापर होची देखा होची system for informed decision making, legalized level database information system for evaluation, use AI to collect information on data flow management, stakeholder engagement, commonly participation in planning and water dispute resolution. ବୁଝିଲ? ତାପରେ ଦେଖିବା ହେଉଛି political and horizontal values, discretion ground, realization statement and subject, non-binding documents, equity versus performance, fragmented water governance, equity and sustainable integrated river management, cooperative federal imbalance, regional deficit grant, governance neutrality, discrete power, informed decision making, political practice question, contradiction, explain Article 280 key for the key recommendation of 16th final body part to challenges in fiscal discipline where high head. Next होती देखिए होती parliament and state legislature structure and function. Disruption in parliament are grand. Now to the बहुत status of parliament disruption 70 block सवाल कौन कहीं disruption इतना से विषय हमें जानना पड़ेगा. देखो now to the produce sitting delay parliament meet on the 270 sitting fewer than the all previous full-time Lok Sabha. Minimum committee scrutiny only 16 bill for parliament committee lowest in the last stage Lok Sabha. 35 bill passed with no less than 1 hour of discussion. Qualified debate. 31% of Lok Sabha, 32 of Rajya Sabha time developed non-legislative discussion. Decline budget examined. Nearly 80% of Union budget declared without debate 2019 to 2023. Reason for the higher parliamentary disruption. Executive dominance. Reduce the parliament to ratify body control agenda. Discuss time motion fuel opposition confrontation. Decline parliamentary ethics on written convention. Restore protest bipartisan cooperation weakening aimed rising confrontation of lawmaking. Decline parliament committee PC fewer bill refer to the PC and their ignorance recommend error institutional trust. Criminalization of politics. MP with criminal charges contribute to poor decorum and aggression. Political polarization. People versus elite. Government versus anti-national. Narrative tone parliament into space for synchrony rather than negotiation. Challenges posed by disruption functioning parliament. Erosion of deliberative democracy. Parliamentary debate consensus building replaced by sloganing and statement. Weakening executive accountability. Curtail question hour, 0 hour limited government action scrutiny. Disruption prevented Manipur violation discussion. Average declining legislative quality. Limited committee scrutiny provide poorly drafted less than limitation law. Law 2020. Normalization disruption. Need for that politics bad parliament disruption. Routine strategy. तापर होची creating vicious cycle बुझला और marginalization of parliament. Parliament risks become an executive rubber stamp and protest area. MP walk out during the DVG Ramji bill बुझला ये सब देखवा पाए पड़िबो. तापर होची existing provision of regularization of parliament function बुझला constitutional provision. Article 118 employment parliament regulate convert business rules of procedure. Details rules in Lok Sabha and Rajya Sabha to maintain order, quorum and discipline. Preceding Officer power, authority to abandon situation, order suppression for forcefully conduct. Next देखा होगा parliamentary committee, ethics privilege committee, propose reform to standing select committee on details legislation scrutiny oversight vigilance. ଏସବୁ ଦେଖିବା ପାଇଁ ପଡ଼ିବ ୱେ ଫରୱାର୍ଡରେ ଦେଖିବା ନା ହେଉଛି mandating minimum sitting at least 120 sitting for the Lok Sabha and 100 for the Rajya Sabha annually. NCRWC 2002 द्वारा कहा establish fixed parliament calendar बुझला legally mandated annual schedule times secular to USA ensure predictability, improve preparedness, reduce disruption, and committee system. All bills should be referred to departmentarily standing committee NCRWC and second ARC. Adoption British model opposition bill. Designation bill where the opposition state agenda providing formal channel for treatment. Example practice parliament allocate 20 days annually. Stability telecast transparency expansion of TV coverage to show entire house including disruption to enhance MP public accountability, strict conduct enforcement, enforce rule like 374 days Lok Sabha to suspend member to specific period of disruption proceeding. Productivity linking incentive and disincentive. Daily allowance of model members should be without for day when house is undergoing due to disruption. Because next Lok Sabha speaker ଉପରେ ଆଲୋଚନା ଦେଖନ୍ତୁ ଲୋକସଭା ସ୍ପିକର why in news in recently ବୁଝିଲା Christian opposition moved a resolution from Humor against Lok Sabha speaker of Umbrella about the office speaker head of the Lok Sabha and represented constitutional office article 93 guardian of the rights and privileges of the member the ultimate intervener and arbiter of provision with related to functioning house removal of Lok Sabha speaker article 19 governor vacation resignation removal of speaker and deputy speaker removal speaker and deputy speaker may be removed by the resolution passed by a majority of all the members of Lok Sabha article 19 during removal proceeding. Speaker cannot decide what must speak, participation and vote in instant, not casting issue in functioning of office speaker with a role over the anti-defection law. A disqualification petition pending for almost 3 years before Manipur speaker in 2020 revenue case 2016 to the SC held the speaker, deputy speaker facing notice of removal. SC held that speaker or deputy speaker facing nothing removal cannot in India case 2016 ବୁଝିଲାନା ଏଇସବୁ ରହିବ ହେଉଛି on declaring modern speaker decision satisfy Aadhaar bill as a money bill ବୁଝିଲାନା and allegation of basis and favoritism. Example suspension of opposition MLA of Tamil Nadu Assembly in 2016 बुझिलाना example तापर देखा where member of a party are indicted and in masses from house while protecting allegation of partisanship in a Britain speaker relinquished party membership for impartiality. In India, this confliction is not observed, affecting speaker impartiality. Suggestion to reform office of speaker. Reduce role of the speaker in anti-defection law in Kaisam Mehta Jaram Singh case. Court the current mechanism while disqualification are entrusted, the speaker can be replaced by replaced by premature premature tribunal. Follow the British model. British model. British convention parties different from opposing speaker during the election to offer facility. ତାପରେ continuous based on performance. ତାପରେ allowing speaker to continue in next parliament. They exhibited impartiality, efficiency during the plenary stage commitment, restricts on political office. Next, take out a vigilant parliament is vital to democracy. The president, officer of parliament are key securing effectiveness of this impeachment. This is important to ensure impartiality, fairness, and autonomy in decision making of speaker. That was anti-defection law. Recently, Supreme Court in Pati Koskredi versus State of Telangana 2025 addressed significant delay by speaker in deciding disqualification petition concern in 10 Telangana anti-defection law. 52nd Constitutional Amendment Act 1985 adding 10th schedule. 10th schedule add କରାଯାଇଛି anti-defection law. ଦେଖନ୍ତୁ ଦେଖିବା to prevent elected MP and state legislator for sweeping political party or violating party directive after their election. Ground for disqualification for the member of House voluntary give up party membership by party vote during the voting. Judicial pronouncement related to anti-defection Quixote on Jajilu 1992. Court should not have the power judicial if the speaker delay. Karnataka MLA disqualification case. Consider the transparency disqualification power primary of an independent tribunal. Argument in favor of ADL. Both stability stop the electoral official for switching party. Government collapse, corruption, prevent unethical practice like buying legislator horse trading. Respect voter, uphold the public church, party and its ideology. Argument against ADM. Limited pay will force legislature to follow party line, not their consent. Violate Article 19 against democratic method. Turns representative of people into the party coalition. Interchange work in innovating idea and dissent on the floor of House. Absolute power to presiding officer. It to decide case related disqualification of member on ground of disqualification. Next ଦେଖିବା ହେଉଛି way forward. ଦେଖନ୍ତୁ way forward ଦେଖିବା second ARC administrative reform committee commission ଯୋଉଟା ହେଉଛି recommended କରିଥିଲା issue of disqualification of member on ground. Defection should be decided by president or governors advise the election commission with an active involvement ethics committee as a down in place of query scam to court the trading horse trading legislator and drive for more clarity. Law must be explicitly set out what it means by what voluntary giving of members. Avoid any consequent conclusion in parliament classified the party displacement is essential. Client utterance of deliberative democracy push the reform like time law said independent adjudication and vital restored credibility to anti-defection design. Next as one of the representatives of legislation they visually report ତାପରେ ହେଉଛି representation of women in legislature बुझेला why in the news since the passage the women reservation bill in 2019 assembly floor have the held in 20 state and UT and only 10.2 women are federated by the political party according to Association for Democratic Reform बुझेला की हाईलाइट बुझेला law representation women manko 14% across the UT and state in UT and after passing bill in 2014 14% of the women manko participation in ମାନେ ହଉଛି women candidate UT and state ରେ ବୁଝିଲା ନା ଏଇଟା ଟିକେ ମନେ ରଖିବ 14% ବୁଝିଲା ନାରୀ ଶକ୍ତି ବନ୍ଧନ ଅଧିନିୟମ 106 Constitution Amendment Act 2023 which seeks to reserve the 33 of seats for women in Lok Sabha and State Assembly and Delhi Assembly बुझिला ना Article 2024 Lok Sabha Policy 152 of 514 constituencies 28% are no women candidate in all are just 74 women MP 14% were elected only 9% ML and national wide are women notable exception Nalam Talimrad Kachti fielded 50% of women candidates, both Puducherry, Tamil Nadu and CPI, and fielded 56 women candidates in the West Bengal Assembly election. बुझला constitutional provision बुझला ना देखिबा कौन सब constitutional provision रही article 325 रे रही बुझला ना देखंदो article 325 ଏବଂ ଗୋଟେ ଆର୍ଟିକଲ ଗୁଡାକ କହୁଛି ଗୋଟେ କ୍ୱାଲିଟି ଫର ଲ women ମାନଙ୍କର ବୁଝିଲା ନା 15 ରହୁଛି 3 ପାର୍ଟ ରହୁଛି ସ୍ପେଶାଲ ପ୍ରୋଭିଜନ ଫର women and କାର women and children ର ବୁଝିଲା ନା ତାପରେ ଦେଖିବା ଅଛି 325 ବୁଝିଲା ନା 325 ରେ 73rd ରେ ଦେଖିବା 73rd ରେ ଅଛି ନା କଣ ଅଛି ନା ଅଛି women ମାନଙ୍କର ଅଛି 1/3 reservation of women in पंचायत राज district 74th ରେ ଅଛି 1/3 reservation in ULB urban local body ବୁଝିଲା ନା 74 ବୁଝିଲା 325 ବୁଝିଲା no discrimination based on gender ବୁଝିଲା sex ବୁଝିଲା ଏ ସବୁ ରହିଛି ବୁଝିଲା ତାପରେ ଅଛି article 326 ରହିଛି adult child କଥା କୁହାଯାଇଛି ବୁଝିଲା ଆଉ ଗୋଟେ କହିବି ଯଦି ଅଛି ଆମର ଆହୁରି ସବୁ କଣ ଆର୍ଟିକଲ ରହିଛି ନା ଅଛି ଆର୍ଟିକଲ ହଉଛି 330 ବୁଝିଲା 330 ରେ ରହିଛି ଏ ବୁଝିଲା 330 ଏ ଆଇ ଥିଙ୍କ ହଉଛି ଦେଖନ୍ତୁ ଏଇଟା କହିଲେ ନା ହଉଛି ଇଲେକ୍ଟେଡ ଏମପି ଲେଜିସ୍ଲେଚର ଆଣ୍ଟି ତାପରେ ହଉଛି ଗ୍ରାଉଣ୍ଡ ଅଫ ଡିସକ୍ୱାଲିଫିକେସନ ରେ କହିଲେ ଜୁଡିସିଆଲ ପ୍ରୋନାଉନ୍ସମେଣ୍ଟ ରିଲେଟେଡ ହଉଛି ଆଣ୍ଟି ଡିଫେକ୍ସନ ର ହଉଛି କିହଟନ କୋଲହନ ଆଣ୍ଡ ଜିଚୁହୁ 1992 ହଉଛି ଜୁଡିସିଆଲ ରିଭ୍ୟୁ ବାହାର କରିବା ନା ହଉଛି ଆଣ୍ଟି ଡିଫେକ୍ସନ ଲ ବୁଝିଲା ନା ତାପରେ ସୁପ୍ରିମ କୋର୍ଟ ଯୋଉ ଡିଲେ ଆକ୍ସନ ନେଇଥିବ ତା ଉପରେ ବୁଝିଲା କର୍ଣ୍ଣାଟକ ଏମଏଲଏ disqualification 2020 और boost stability argument in favor of ADM boost stability cause corruption respect voter बुझिला argument against anti-defection law limit free power ताकि against democratic ethos hinder change absolute power to presiding over बुझिला एटा कहितले ना ARC बुझिला ARC president representation second ARC रे कहा जायतला ना माने decided by anti-defection should be decided by president and governor on advice of PC active involvement of ethics committee बुझिला ना तापर होची bringing more clarity explicitly set out what mean by word voluntary give of conclusion तापर parliament democracy. Party dissolution essential bind adherents to whip undermine restore credibility for anti-defensive ତାପରେ ରିଜର୍ଭେସନ ଲେଜିସ୍ଲେଚର ଓମେନ୍ ଲେଜିସ୍ଲେଚର ଏଇଟା କହିଥିଲେ 2023ରେ ହଉଛି ଓମେନ୍ ରିଜର୍ଭେସନ ପାସ୍ ହେଇଥିଲା ବୁଝିଲା ନା ତାପରେ 14% ରେ ହଉଛି ୟୁଟି ଷ୍ଟେଟରେ ମାତ୍ର 14 ୟୁଟି ଆଉ ଷ୍ଟେଟରେ 14% ଓମେନ୍ ମାନେ ରିପ୍ରେଜେଣ୍ଟେଡ୍ ରହୁଛନ୍ତି ବୁଝିଲା ନା ରିପ୍ରେଜେଣ୍ଟେଡ୍ ରହୁଛନ୍ତି ତାପରେ ନାରୀ ଶକ୍ତି ବନ୍ଧନ ଅଧିନିୟମ 106 ଆମେଣ୍ଡମେଣ୍ଟ ଆକ୍ଟ 2023 ଆସିଲା 33% ରହୁଛି ଓମେନ୍ ଲୋକସଭା ଷ୍ଟେଟ୍ ଆସେମ୍ବଲି ଦିଲ୍ଲୀ ଆସେମ୍ବଲି 2024 ଲୋକସଭାରେ ହଉଛି 152 by 543 constituents are no women candidate are not just 74 MP ହଉଛି 74 ମାତ୍ର ହଉଛି 543 ରୁ ବୁଝିଲା ନା ଓମେନ୍ ମାନଙ୍କର ରିଜର୍ଭେସନ ରହିଛି ବୁଝିଲା ନା ମାନେ ସିଟ୍ ଟା ରହିଛି 74 ମାନେ ଯୋଉଟା 14% କିନ୍ତୁ ତାକୁ 33% କରିବା ପାଇଁ ଚେଷ୍ଟା 1/3 କରିବା ପାଇଁ ଚେଷ୍ଟା ହେଇଛି ବୁଝିଲା only 9% MLA national wide are MLA ମାନେ national wide 9% ଦେଖିବା ନା ହଉଛି ଦେଖିବା ହଉଛି 14% ହଉଛି article 14 equality with all ତାର ହଉଛି 15 special provision for women and children 74 ହଉଛି 1/3 এটা constitutional provision ଗୁଡାକ କହୁଛି ବୁଝିଲା ତାହେଲେ ହଉଛି ତାପରେ ହଉଛି ଦେଖନ୍ତୁ ନା ହଉଛି 325 ରେ ହଉଛି ରହିବ ନା ହଉଛି ଆମ ସରି 14 ରେ କହିଲେ ତାପରେ 74 ରେ 1/3 reservation in local self government पंचायत राज हଉଛି 74 1/3 reservation in urban local ତାପରେ article 325 ରେ ରହିଛି no provision based on gender based ଦେଲା ନା ମାନେ no discrimination ରହୁଛି article adult franchise universal adult franchise କଥା କୁହାଯାଇଛି article 330 ରେ କୁହାଯାଇଛି ନା women representation in କେତେ ରହିଛି ନା ହଉଛି women representation in ହେଲା women representation in ଲୋକସଭା କଥା କୁହାଯାଇଛି 332 for ଅଛି women representation ରାଜ୍ୟସଭା କୁହାଯାଇଛି 334 କଥା କୁହାଯାଇଛି ବୁଝିଲା ତାପରେ ଅଛି ଏଇଠି କହୁଛୁ କୁହାଯାଇଛି ମାନେ women ମାନଙ୍କର କେତେ ସମୟ ପାଇଁ ମାନେ ହଉଛି ରିଜର୍ଭେସନ ରହିବ ଆଉ କେମିତି ଇମ୍ପ୍ଲିମେଣ୍ଟେସନ ହବ ତା ବିଷୟରେ 106 ଆର୍ଟିକଲରେ କଣ କରାଯାଇଛି ନା ହଉଛି 106 ଆର୍ଟିକଲରେ କୁହାଯାଇଛି ଯେ 106 ଆର୍ଟିକଲରେ କୁହାଯାଇଛି ଯେ ହଉଛି ପାର୍ଲାମେଣ୍ଟ ଓ ଆସେମ୍ବଲିରେ କେତେ ସମୟ ତାଙ୍କର ରହିବ ବୁଝିଲା ତାପରେ ଦେଖନ୍ତୁ ଏଇଟା ମୁଁ କହିଛି ବୁଝିଲା ଏଗୁଡାକ କହିଛି ଟୋକେନିଜିମ୍ ପ୍ରକ୍ସି ରିପ୍ରେଜେଣ୍ଟେସନ ଏଗୁଡାକ କିୱାର୍ଡ ଗୁଡାକ କ୍ୟାଷ୍ଟ ଟିକେଟ ଡିସ୍କ୍ରିପସନ ସେଫ୍ଟି କନସର୍ନ ଉପରେ ଆଲୋଚନା କରିବା ନାରୀ ଶକ୍ତି ବନ୍ଧନ ଅଧିନିୟମ 2023 representation पंचायत राज म्युनिसिपालिटी एसटीजी 5.5 कमिटमेंट बुझिला ना ए सब रहिछि बुझिला ना कीवर्ड रहइबो नेशनल ऑफ डेलिगेटेड डेमोक्रेटिक सिटिंग दिले बुझिला एगुडा कीवर्ड गुडा देखबा जे हॉर्स राइडिंग बुझिला एटी कोन अछि हॉर्स ट्रेडिंग allegation of insurable एमसी सब प्रैक्टिस क्वेश्चन रहइबो अछि ना अछि frequent disruption of affected parliamentary ability status of disruption like voting within for parliament challenges posed by going forward the structure and function of judiciary and other body quasi judicial body से विषय आलोचना करिबा बुझिला ଦେଖନ୍ତୁ structure and functioning of the judiciary and other quasi-judicial body ବୁଝିଲା judicial appointment why in the news ବୁଝିଲା recently SC agreed that consider a PIL question collegium system appointment of judge into the top HC seeking revival National Judicial Appointment Commission NJSC about the NJSC Act 2014 established by 99th Constituent Amendment to replace collegial system for higher judiciary appointment appointed by 6-member commission CGI, 2 senior judge, union law minister and 2 eminent person. Judicial verdict struck down in the fourth judiciary case 2015 for violating basic structure judicially independent present system for judge appointment in the India. ବୁଝିଗଲା ତାପରେ ଦେଖିବା ହେଉଛି CGI president under the article 124(2). However, the article 124 does not specifically mention CGI separately. It idle with appointment of every Supreme Court judge, including CGI by convention. Senior most SC judge in appointment as a CGI appointment. Appointing a Supreme Court judge is a collegium system which is developed through 3 judge-based cases. Supreme Court appointment collegium consists of CGI and 4 other senior most judge of SC. Within SC appointment collegium system at constituent of CGI and 2 senior most judge of Supreme Court. For SC judge within present consultation with CGI and other HC judge and constitution article 124 for Supreme Court judge president consulate CGI Chief Justice concern of Article 207 concern related judicial appointment and collegium system. Opinions accountability deficit collegium decision are not answerable external authority, neither parliament nor executive. Exclusionary by nature. Collegium criticism limited representation of women and marginal community. Constitutional ambiguity. Collegium system emerged from judicial interpretation. Raise concern over the parliament roles. Institutional design. Vaccine. Persistent Stafford between the collegium and executive. Delay appointment. Judge undermine separation of power and principle of checks and balance. Administrative challenges. Appointed transforming judge insufficient without a dedicated secretariat or background check mechanism. Next ଆସିବ ନା ହେଉଛି step to ensure in judicial appointment. ବୁଝିଲ establishment evaluation committee SCA enhance the transparency, eligibility criteria, formulate and police in disclosing object eligibility standard for assessing job, inclusive selection process, transparent appointment with wider institutional participation. Law commission recommending restoring CGI primacy or involving executive public disclosure, make a collegium decision public to reduce secrecy in appointment. Conclusion. While collegium system safeguard judicial independence, the concern mean reforms such as restricted NJSC with safeguard for collegium plus ensuring transparency, accountability and diversity. Women in judiciary. ବୁଝିଗଲା ନା women ମାନଙ୍କର judiciary ବିଷୟରେ ଏବେ ଆଲୋଚନା କରିବା. ବୁଝିଗଲା ନା ଦେଖନ୍ତୁ evaluation of the Supreme Court evaluation of collegium system in India 1981, 1993, 1998 ବୁଝିଗଲା ନା ତାହେଲେ ହେଉଛି 81 ରେ କ'ଣ ହେଇଥିଲା 93 ରେ କ'ଣ 98 ହେଇଥିଲା ବୁଝିଗଲା ଦେଖ ଫାର୍ଷ୍ଟ ଜଷ୍ଟ କେସ୍ ରେ ହେଇଥିଲା ନା ହେଉଛି rules executive can refuse CGI recommendation for judicial appointment ବୁଝିଗଲା ମାନେ Supreme Court rule executive can refuse CGI recommendation for judicial appointment ବୁଝିଗଲା judicial appointment by executive can refuse CGI recommendation ବୁଝିଗଲା ତାପରେ ହେଉଛି second judge can control only 2 senior most judge for appointment and transfer ବୁଝିଗଲା ମାନେ 2 senior most judge ହେଉଛି for appointment ବୁଝିଗଲା collegium ତାପରେ ହେଉଛି CGI most consular senior most सुप्रीम कोर्ट जज फॉर अपॉइंटमेंट ऑफ ट्रांसफर बुझेला ना ताला होची ना होची सीजीआई मोस्ट कॉन्सुलेट फॉर सीनियर मोस्ट जज फॉर अपॉइंटमेंट एंड ट्रांसफर बुझेला ना ताप होची देखिबा होची नेक्स्ट होची वुमेन जुडिशियरी बुझेला ना वुमेन जुडिशियरी रे व्हाई इन द न्यूज बुझेला एड्रेसिंग द फर्स्ट नेशनल conference Indian Women in Law CGI emphasized need for greater women representation of judiciary current status of women judiciary Supreme High Court only one woman judge बुझेला नहीं judge out of 33 बुझेला नहीं High Court 14.85% of judge are women बुझेला ताकि डिस्ट्रिक्ट कोर्ट 37 women judge बुझेला रीजन फॉर लॉ रिप्रेजेंटेशन seniority cum merit criteria favoring long term tenure traditional dominated by men which structural barrier male dominant collegium appointment system limit their representation in senior position in workplace issue gender basis for infrastructure is a hinder professional growth leak pipeline women enter judiciary but few reach higher court despite qualification importance of women in judiciary ensuring gender equality promote equal participation in decision making gender sensitive justice women judge diverse life experience than influence judicial reasoning approach आसवा नेक्स्ट होची public trust and legitimacy representing judiciary enhance as credibility of the judicial system role model encourage more women to enter legal professional and judiciary a reform measure to improve women representation in judiciary inclusive judicial appointment institutionalized gender diversity as a formal criterion in Supreme Court and HC appointment reservation in judicial service and legal institutions example of the Supreme Court direct bar association to modern 30 elected seat and office bearer post to women mentorship and leadership program for women lawyers and judges improve work and infrastructure safer court and environment and better work place facility and currently women in litigation for strengthen promotion pipeline for women advancement next देखिबा होची जुडिशियल पेंडेंसी आर्ट क्लास जुडिशियल पेंडेंसी आर्ट क्लास कोन पे रहउची बुझला से विषय मु आलोचना करिबे देखो जुडिशियल पेंडेंसी फॉर पेंडेंसी ऑफ केसेस बुझला लॉ जज पॉपुलेशन रेशियो 21 जज आज पर मिलियन recommended 5120 law combination बुझला तापर जे इंफ्रास्ट्रक्चर गैप रहउची बुझला इंफ्रास्ट्रक्चर गैप रे कोन रहउची ना होची लिमिटेड स्टाफ technology and digital adoption तापर under use alternative dispute resolution mechanism like terminal remain effective बुझला financial constraint judiciary get only 0.1 of GDP much lower than the defense बुझला तापर procedural delay multiple appeals attendant focus case are with case management तापर government litigation 50% of case involve government and agency the impact of judiciary dependency बुझला ना कौन सब judiciary dependency रही से विषय आलोचना करबा fundamental right violation बुझला ना delayed trial violation article 21 as held Hussainara Khatun versus State of Bihar 1979 denying right to speedy trial बुझला delayed trial violated article 21 as held Hussainara Khatun versus State of Bihar 1979 by delaying right to speed trial social impact on under trial 17 reasons upon long consideration without conviction economic impact escalated litigation cost particularly on stall development project due to land acquisition and environment clearance loss of trust citizens sometimes opting for the solution, black and post syndrome, systematic delay in justice defense static बुझला तापर scheme and initiative by government to reduce expectancy बुझला national mission for justice delivery and legal reform NMJDRL 2021 reduction of barrier and delay infrastructure procedural reform central sponsored development of infrastructure for judiciary e-court mission model project phase 1 phase 2 and computerization of courts e-filing video conferencing etc commercial courts under the commercial court act 2015 with a faster disposal of commercial disputes fast track court মানে হচ্ছে example হচ্ছে NIA courts POSCO courts etc finance crime ADR mechanism lock अदालत education arbitration etc বুঝলাম next ଦେଖିବା ହଉଛି National Judiciary Infrastructure Authority JIC established central authority to mandated AI and judiciary justice NV Raman AD of judge appointment experiment retired judge in SC under Article 128 and 224A target and review set case disposal target conduct performance report control adjudication regulate privileges of technology reform litigation reduce government case clarify law ensure compliance discourage fiducial law ବୁଝିହେଲା ନା next ଦେଖିବା ନା ହଉଛି promote ADR legal service authority should undertake free litigation medication ବୁଝିହେଲା next ଦେଖିବା ହଉଛି ନା ହଉଛି ଦେଖନ୍ତୁ ଦେଖିବା ହଉଛି tribunals ବୁଝିହେଲା recently Supreme Court struck down the Tribunal Reform Act 2020 on regulating appointment, tenure and service condition of member of various tribunal. Key highlight judgment significance of tribunal. देखिए ना special jurisdiction, speedy resolution, reduce judicial burden, accessibility, effective service matter. बुझेला तापर देखिए key highlight judgment. बुझेला legislative override of judicial direction on 2021 Act conflict with binding SC ruling on tribunal appointment tenure and functioning in Madras Bar Association case 2020 MVAIV and 2021 MVAV violation of constitutional supremacy primacy enacted struck down provision without curing deficiency undermined separation of power and judicial independence within present data direction in MVAIV and MVAV will apply until a new law in enable key constitutional issue in Act Vice Supreme Court Judgment Tribunal Reform Act 2021 Supreme Court Judgment tenure and age limit for your tenure minimum age 50 for appointment search selection committee then recommend chairperson member of appointment to central government composition of above committee CGI or SC judge nominated by CGI as chairperson to secretary central government outgoing chairperson for new chairman and stating for a tribunal judicial system in India Koji judicial body establish a adjudicate dispute related specified matter constitutional recognition 42nd Constitutional Amendment Act 1976 added a new part XIVA Constitution which inserted Article 323A and Article 323B 323B Article 300A empower constitutional administrative tribunal both central and state level for adjudication of matter related to recruitment condition and service public article and Article 323B specifies certain subject transaction land reform which parliament and state legislature may constitute tribunal and Chandan Kumar case Chandan Kumar case Chandan Kumar case 2017 रे कौन होला SC held appeal against decision. Tribunal were allowed in the division bench of High Court. Constitutional balance between judicial dependency and parliament sovereignty in India. Check and balance power are divided among the legislative, executive, and judicial. Parliament frame law and policy, while the courts test their constitutionality. Constitutional supremacy बुझेला constitutional supremacy के both parliament and judiciary are subject to constitutional not superior each other. Judicial review under the Article 13 court can strike down law and that violate fundamental right and basic structure. Limit on parliament amendment power. Constitutional amendment needs speedy majority. Sometimes state ratification cannot be damaged of basis of structure. Immunity and surveillance. MP enjoy immunity for speedy justice for votes in parliament. Conduct SC and HC judge for cannot be debated except during the infringement process. Conclusion. While there have the instant judicial activism, parliamentary legislative overriding court ruling, healthy and convention respect boundary each that neither institution hold बुझेला absolute power. तापर होची देखिबा होची नेक्स्ट होची क्रिमिनल जस्टिस इन इंडिया एट ग्लांस बुझेना देखिबा होची क्रिमिनल जस्टिस नकर इंडिया रे केमती क्रिमिनल जस्टिस सिस्टम इन इंडिया बुझेला देखिबा criminal justice is a framework mechanism involving crime prevention, investigation, prosecution, punishment and rehabilitation, principle, deterrence, retribution, incarceration, rehabilitation and repression. बुझे ना law conviction case pendency बुझे ना देखो order case माने होची 43.8% अच्छी रेप होची 27.4%. NCRP डाटा 2022 बुझे ना मर्डर होची 43% बुझे ना मर्डर कौन होची 43.8% मर्डर रेप रही होची 27.4. NCRP डाटा नेशनल क्राइम रिकॉर्ड ब्यूरो बुझे ना केस पेंडेंसी 4.7 करोड़ पेंडेंसी बुझे ना मु एबे डिटेल्स डाटा देउची बुझे ना देखो सुप्रीम कोर्ट रे 92,000 बुझेला ना केस पेंडेंसी रहला वाला हाई कोर्ट रे 63 लाख समथिंग अछि आउले डिस्ट्रिक्ट कोर्ट एंड सबऑर्डिनेट कोर्ट रे 4.5 लाख केस पेंडेंसी रही छी को द्वारा नाट ग्रेड नाट ग्रेड के मु देखु छी से डाटाटा होची के पब्लिश करतला ना होची मु देखु छी से एटा जो पब्लिश करि छी एटा होची के ना NJDG देना DG नेशनल जुडिशियल डाटा ग्रिड द्वारा हेची एटा होची पब्लिश करा जाय छी बुझला ना तापरे देखंतो टेक इवोल्यूशन नीड टू मॉडर्नाइज एविडेंस कलेक्शन एंड स्टोरेज बुझला ना फॉर एक्सट्राडिशन रेट in 2020 fugitive suggestive extradited बुझला मैन पावर शॉर्टेज 192 policy for lakhs non for only 21 judge are million बुझला न्यू लॉ भारतीय न्याय संहिता बुझला ना भारतीय BNS भारतीय न्याय संहिता तथापि BNSS भारतीय न्याय सुरक्षा संहिता बुझला ना तथापि BSA भारतीय साक्ष्य अधिनियम बुझला ना ए सब नुआ लॉ आसी बुझला देखो विटनेस प्रोजेक्शन स्कीम 2018 फास्ट ट्रैक स्पेशल कोर्ट ओपन वॉरियर राजस्थान मॉडल noted in NCR 2023 criminal procedure identification act 2022 बुझला ना नेक्स्ट देखिबा होची देखंतो ना होची पॉलिसी रिफॉर्म बुझला पुलिस रिफॉर्म प्रकाश सिंह केस 2006 बुझला 2006 रे हसलो प्रकाश सिंह माने पुलिस रिफॉर्म विषय आतला बुझला स्टेट सिक्योरिटी कम्युनिकेशन एंड चेक पॉलिटिकल इंटरफेरेंस मेरिट बेस्ड NGDP डाटा 2 years minimum tenure बुझला policy established board to handle transformation and promotion बुझला national judiciary communication for central policy leadership strengthening prosecution operational and financial independence for department of prosecution बुझला मलिमत कमिटी रेकमेंड पहला ना होची आर्टिकल 2023 ରେ 2023 ରେ modify right to silence of accused ବୁଝିଲା rights of accused code of published to regional language ବୁଝିଲା ନା code to be published ମାନେ ହଉଛି in regional language evidence law allow dying declaration audio visual record confession ବୁଝିଲା public prosecution ମାନେ ହଉଛି recruitment assistant public prosecutor via competitive exam ବୁଝିଲା ଦେଖନ୍ତୁ criminal law reform act ବୁଝିଲା why the news 3 new criminal law ଭାରତୀୟ ନ୍ୟାୟ ସଂହିତା ଭାରତୀୟ ନାଗରିକ ସୁରକ୍ଷା ସଂହିତା ତାର VS ଭାରତୀୟ ସାକ୍ଷ୍ୟ ଅଧିନିୟମ ଦେଖନ୍ତୁ ମୁଁ ଆଗେ ସର୍ଟ ଫର୍ମ କରିକିନା ମନେ ରଖିଦିଏ BNS ତାପରେ ହଉଛି BNSS ବୁଝିଲା ଭାରତୀୟ ସାକ୍ଷ୍ୟ ଅଧିନିୟମ came into across the country on July 1 2000 complete 1 year ବୁଝିଲା ନା ଦେଖିବା ହଉଛି ଦେଖନ୍ତୁ ଦେଖିବା ହଉଛି ବିଭିନ୍ନ ପ୍ରକାର ଫିଚର ବୁଝିଲା ଭାରତୀୟ ନ୍ୟାୟ ସଂହିତା 2023 ବା BNS ବୁଝିଲା replace the IPC 1860 को replace कला updated provision on considered criminal law and incorporated recommendation on women safety food adulteration and death penalty भारतीय नागरिक सुरक्षा संहिता BNSS 2023 बुझला replace CRPC 1973 governing criminal procedure modernized investigation prosecution and trial process बुझला भारतीय साक्ष्य अधिनियम PSA 2023 replace Indian Evidence Act 1972 update evidence law for digitalization technology advancement बुझला key provision ରହିବ community service for the minority option rages age in page provision from to 16 to 18 years बुझला ना BNS Act 16 to 18 years age in a provision from to 16 to 18 years criminal sex deficit false promise बुझला ना तब define terrorism and organized crime बुझला ना BNS रहउछि terrorism को organize कर remove sedition offense बुझला potential impact कौन सा रहउछि ambiguity in term like criminal activity wider police discretion concern over trial delay बुझला ना next देखिबा होछि under eligible for release after serving 1/3 of maximum sentence mandatory forensic investigation of serious offense expanded marriage power of biometric collection fixed timeline and charge sheet victim of death faster disposal cases greater technology investigate improve victim right and transparency बुझला ना चलो जी भारतीय न्याय भारतीय नागरिक सुरक्षा सहायता रहउछि कौन देला न होछि ये काको रिप्लेस कला न होछि CRPC 1973 को रिप्लेस कला बुझला तापर होछि ये जो एविडेंस तापर ये जो अंडर ट्रायल एलिजिबल रिलीज आफ्टर सर्विंग 1/3 of maximum sentence बुझला और mandatory forensic investigation for serious offense बुझला forensic investigation रहइबो expanded magistrate bar for biometric collection बुझला fixed timeless for charge sheet and victim of death faster disposal of cases greater use of technology in investigation improve victim right and transparency बुझला next as per recognize and digital evidence expand admissibility of electronic record allow oral evidence through means allow trial and absconding accused with a joint trial strengthen digital evidence framework enhance efficiency evidence collection raise concern over privacy and sovereignty significance of new criminal law significance of new criminal law justice over punishment from criminal punishment to justice based system करा गला victim रो right को timely trial मध्ये देखा गला fair and transparency process digital like fair forensic evidence Indian value at core धर्म and न्याय technology driven justice system e साक्ष्य evidence someone is someone noted at the UTS ମାନେ UT 11 state and UT ନ୍ୟାୟ ସ୍ୱୀକୃତି ନ୍ୟାୟ ସ୍ୱୀକୃତି ବୁଝିଗଲା ଯୋଉଟା ହଉଛି ନ୍ୟାୟ ସ୍ୱୀକୃତି enable courts to hearing witness testimony by video conference implement in 6 state and UT crime and criminal tracking network system. The CCTNS network cover 14,000 police stations, 20,000 courts are online, 23 states have completed 1,000 capacity building and training. Community service introduced as a penalty, 12 state and UT. Challenges in implementing new criminal law, BNS, BNS, lack of adequate infrastructure support, example, severe police station court, regional lack of international tools enable digital arrest. ତାପରେ ଦେଖିବା ଅଛି PNS set justice timeline but lack enforce is example 22 vacancy policy district judiciary mark a deadline too hard to meet with PNS and PSN forensic but implementation suffer due to 47% administrative and 49 scientific vacancy. That enacted IPC new shift formal punishment justice and like forensic integration fixed timeline offering decolonization and criminal justice. ଗୋଟେ ଏବେ କହିବି ବୁଝିଲା ଗୋଟେ ମୋର ମନେ ପଡୁଛି ଗୋଟେ ହଉଛି କେସ୍ ଅଛି DK ବାସୁ versus state of West Bengal ବୁଝିଲା ଏଠି କଣ କରାଯାଉଛି କ୍ରିମିନାଲ କଷ୍ଟୋଡିଆଲ ସେଫଗାର୍ଡ ବିଷୟରେ ବର୍ଣ୍ଣନା କରାଯାଇଛି ବୁଝିଲା କଷ୍ଟୋଡିଆଲ ସେଫଗାର୍ଡ ବିଷୟରେ ବର୍ଣ୍ଣନା କରାଯାଏ ଆଉ ଗୋଟେ ଅଛି ନା ହଉଛି ଦେଖିବା ହଉଛି ହୁସିନାରା ଖାତୁନ ବୁଝିଲା ନା କେସ୍ କଣ କରାହେଇଛି ନା ହୁସିନାରା ଖାତୁନର କେସ୍ ହଉଛି 1979 ରେ ଆସିଥିଲା ବୁଝିଲା ଏଇଠି କଣ କରାଗଲା ନା ହଉଛି ସ୍ପିଡି ଟ୍ରାଏଲ ବୁଝିଲା ସ୍ପିଡି ଟ୍ରାଏଲ ଅଣ୍ଡର ଆର୍ଟିକଲ 21 ରେ ଅଣାଗଲା ବୁଝିଲା ନା ସ୍ପିଡି ଟ୍ରାଏଲ ଆଉ ଗୋଟେ କେସ୍ ଅଛି ମୋର ମନେ ପଡୁଛି ଯାହା ବୁଝିଲା ନା ନାଇଁ ଗୋଟେ ହଉଛି କଣ ନା ହଉଛି मेनका गांधी वर्सेस यूनियन ऑफ इंडिया बुझल मेनका गांधी वर्सेस यूनियन ऑफ इंडिया बुझला यूनियन ऑफ इंडिया सेट रे कोन कहा जायतला न होची जो प्रोसीजर मस्ट बी बुझला अंडर आर्टिकल 21 फ्री एंड फेयर हेबा दरकार बुझला ना प्रोसेसटा फ्री एंड फेयर हेबा दरकार बुझला आ गुटे होची ललित कुमारी केस बुझला ललित कुमारी केस रे कोन अछि एफआईआर को बुझला एफआईआर को माने मैंडेटरी निश्चित रूप से ताको करा गला बुझला तापर होछि अनेश कुमार बुझला अनेश कुमार केस को कोन करा गला ना होछि माने होछि अनेश कुमार केस को कोन करा जायछला ना मते जहां मने पडुछि ना होछि अनेश कुमार केस को कोन करा जायछला ना होछि अवॉइड unnecessary arrest बुझला एमती सब अच्छे बुझला ना।
ये अंतिम अध्याय है, यहाँ से या तो परिस्थिति बदलेगी या फिर मैं बदलूंगा। तो आप लोगों को याद होगा सुल्तान मूवी का वो डायलॉग, जब उसके गुरु से आकर पूछते हैं कि भाई तेरे अंदर क्या चल रहा है, वर्ड ये था कि तेरे भीतर क्या चल रहा है, तो कहता है कि ना तो मैं बता पाऊंगा और ना ही आप समझ पाएंगे, ये मेरी खुद से खुद की लड़ाई है, अब बस अपनी औकात बदलनी है। तो जिस इंसान ने अपने आप को समझ लिया कि भाई तुझे ही तेरी औकात बदलनी पड़ेगी, वरना लोग जो है तुम्हें थप्पड़ मारकर निकलेंगे और इस समाज के अंदर में कोई रिस्पेक्ट नहीं मिलेगी जब तक कि आप लोग खुद से ये न ठान लो कि यार अपनी औकात बदलनी है। तो या तो परिस्थिति बदलेगी या फिर मैं बदलूंगा। इतना जुनून तो आप लोगों को लेकर आना ही पड़ेगा। अगर आप लोग को लग रहा है कि यार नॉर्मल चलते चलते एक दिन किसी तरीके से कोई अलादीन का चिराग घिसेगा और उसमें से कोई जिन निकलेगा और आप लोग की लाइफ बदल